let's go to Lake County, Ohio. We'll say good morning to Judge Vincent Culotta, the Kool-Aid Man, as I'm calling him in my brain.
Your Honor, here this morning in the state of Ohio versus David Graves on two case numbers, the first being 24 CR 35 for a probation violation final hearing, the second being 25 CR 1342. On a prior day of court, the defendant did plead guilty to count 1, possession of cocaine, a felony of the 4th degree, and count 3, OVI, a misdemeanor of the 1st degree. Your Honor ordered a updated pre-sentence report on that case, which has been completed. We are here today for the purposes of sentencing.
He doesn't play to the PV, right? We need to do that first.
Correct, Your Honor. I think we just waived the probable cause. I don't think the
You're right.
final hearing's been officially waived.
We're going to address that first then. Case 24 CR 035, scheduled for a final hearing. Mr. Watts, what's the defendant's intention in that regard?
Thank you, Your Honor. May it please the court, after talking with my client, he is prepared to waive his final hearing and enter a plea of guilty to the violation, Your Honor.
Thank you. All right, Mr. Graves, in the first case, one that you've been on probation to the court for, you're charged with violating the conditions of your community control sanctions. Specifically, there's 3 alleged violations. The first is a Rule 1 violation, which requires you to obey all local, state, and federal laws, and it's alleged that on September 14th of this year, 2025, you were cited by the Whitcliffe Police Department for possession of a controlled substance, resisting arrest, open container, operating a vehicle under the influence of alcohol or drugs, and failure to control. That's the other case that we have before us. You're ultimately pled guilty to the possession of cocaine charge in an OVI. It's also alleged you violated Rule 8, which prohibits you from using, possessing, or having under your control any controlled substance not prescribed to you by a licensed physician. It's alleged that on that day, that other incident, September 14th, you were in possession of controlled substances, and you ultimately pled guilty to the charges for that. There's also a supplement or an addendum that was filed alleging another Rule 8 violation, again, which prohibits you from using any controlled substance, and it's alleged that a urine sample you submitted on September 16th after you were arrested tested positive for cocaine and marijuana. Now, you have the right to have a final hearing regarding these allegations, and that's a hearing where the state would be required to prove the merits of what they're alleging. Now, you could have this hearing, but you can also waive the hearing and plead guilty to the violation. Your lawyer has indicated he believes that's what you want to do, waive the final hearing and plead guilty. Is that correct?
Good morning. Yes, Your Honor.
Well, before I can accept your waiver of the hearing and your plea of guilty, I need to make sure you understand the potential consequences you face if you are found, in fact, to have violated the conditions of your community control sanctions. If, in fact, that did occur, the court could extend your probation up to 5 years. I can impose more restrictive sanctions against you, or I could terminate your probation and send you to prison. If I did that, it could be 6 to 12 months in prison, and that could also be ordered to be served consecutive to any potential prison sentence that may get imposed for the new case, the other case that we are here for on sentencing. You understand the potential penalties you face if you're found to have violated your community control sanctions?
Yes, Your Honor.
Well, having been so advised, what do you want to do at this time? Do you want to have the final hearing, or do you want to waive that hearing and plead guilty to the violations?
Plead guilty, Your Honor.
Very well, then, as to the allegation that you violated Rule, let me get that up here. That you violated Rule 1 by having been convicted of a new criminal offenses. What is your plea to that?
Guilty, Your Honor.
As the Rule 8 violation for being in possession of controlled substance, what is your plea to that?
Guilty, Your Honor.
And as to the Rule 8 violations set forth in the addendum for testing positive for marijuana and cocaine, what is your plea to that?
Guilty, Your Honor.
All right, the court will accept your plea as of guilty, find that you did violate your community control sanctions in case 24 CR 035. We will now proceed to sentencing in that case as well as the sentencing in 25 CR 1342. We'll do both together. Any reason not to do that, Mr. Watson, or any reason not to proceed to sentencing in either of these cases?
No, Your Honor.
Then is there anything you'd like to say on behalf of your client in regards to both of these cases? Make your comments and obviously go for both cases.
Thank you, Your Honor. May it please the court. Yeah, I'm going to be brief. I know we had discussions in chambers. Mr. Graves, I believe, is a good person who's got a very serious problem. I know he's denied this problem to not only this court, to probation in the past. I think in discussions in chambers when probation brought up that it finally caught up to him, I actually thought that was very appropriate. I think it did. And unfortunately, how it caught up to him on this new case, the facts are obviously not good at all. He was behind the wheel of a vehicle, passed out. The vehicle was still in drive, on the road. And it took officers. They had to get into the car, put it in park. Took them a while to wake him up. Obviously, the cocaine was found as well. Your Honor, Mr. Graves has told me that he struggled with this for quite a long time. He knows this court previously gave him really 2 chances. They gave him a chance, and then I believe there was a probation violation on the old case already, and continued him on probation. So. And he was doing well there, I believe, for a while. Unfortunately, he fell off the wagon and hard. And Your Honor, we're here hand in hand. I know the court can do a lot today, has a lot of discretion with regards to sentencing. I'm going to respectfully ask the court to consider a minimum sentence on both cases. Mr. Graves has expressed to me that he knows he's got some time ahead of him, but he plans on utilizing that time wisely. He wants to enter into some programs, do some AA. He wants to get out sober, and he wants to be sober. He doesn't want to be in this position ever again. He's expressed to me he's getting older. He's tired of this. He's tired of living his life like this, and I'm going to respectfully ask the court to take into account that he has accepted full responsibility here. He's very remorseful, and I'm hoping he'll get the help that he needs. Thank you, Your Honor.
Thank you. Mr. Graves, you have the right to address this court before you're sentenced in both of these cases. Is there anything you'd like to say in either or both cases at this time?
Your Honorable Judge Culotta, please accept this letter as I have written for mercy in regards to my crime I have committed, in which I am truly apologize and must first explain that I am reason to believe this is the root because of my actions and behaviors as a child growing up without a father figure. Or just to say that I'm sorry, and I do have a problem, and I'm sorry that I came in front of you and everything. And I have my own business and everything. I'm trying to just ask for the minimum on my fines, minimum on my license and driving privileges. And I apologize. And I have a problem, and I want to use this time, like you said, that you give me and everything to help better myself. And got 8 kids, 7 grandkids, and all like that, and everything, Your Honor. And just asking for plea for the mercy on the courts, Your Honor. I got a long letter. I ain't gonna take up. I said I have a long letter. I ain't gonna try to read. Take up a lot of time.
Well, you can say whatever you'd like to say. I'm not limiting you at all. It's up to you.
It's just above. And like I said, both my parents, they died of overdoses, and Mama was a prostitute. I was grown at 14, and I just made the wrong choices in life and all, and that's all. That's all, Your Honor. Just thank you for the mercy of the courts.
Thank you. Mr. Watson, anything else?
Nothing further, Your Honor.
Contract for the state of Ohio.
Thank you, Your Honor. The state is recommending prison on both of these cases. By my review of the pre-sentence report, the defendant has 8 prior misdemeanor cases, 7 prior felony cases. He was on probation at the time that he committed this new offense. The facts of that new offense are very serious. There is nothing that I see that would recommend him that he is amenable to community control sanctions, so we would ask for prison on both cases. Thank you.
Thank you. This court has reviewed the pre-sentence report investigation that was done in both cases, the original PSR done in the 24 case, as well as the updated PSR that was just completed. There's also a drug and alcohol evaluation that was completed in this newer case. I've read and considered that. I've considered the facts and circumstances of both cases, the nature of the cases involved. I've considered everything that's been said here today. All of this is considered in light of the purposes and principles of felony sentencing set forth in 2929 11 of the revised code. As for the factors in 292912 in the older case, the 24 CR 035 case, I'm going to incorporate all the findings I made at the original sentencing hearing, first PV, with the additional finding at this time that the defendant has, again, failed to comply with the previously imposed sanctions ordered by this court, which is a factor indicating recidivism is more likely. In fact, one of the findings, one of the violations was for actually committing a new crime, so recidivism actually occurred. In regards to the 25 CR case, the court notes in regards to the seriousness factors, just the very nature of the offense itself makes this much more serious than normal. Quite frankly, it's only not fine possession, I get it, but it's one of the worst ones I've seen. You're stopped at a red light, cars and drive, with your foot on the brake for a long time. There's one woman that pulled up behind you, sat through a whole cycle, then she left to go pick up somebody, came back and you were still there. People were beeping their horn, knocking on windows, reaching in your car, and you had no idea. And you're driving a car in that condition. Putting everybody in the community and everybody in that area at risk. You want to harm yourself by using drugs or drinking, whatever, but when you put the other people at risk, that makes it much more serious, and that's what happened here. And the officer in this case opened the door, put the vehicle in park, removed the key, you didn't wake up. Yelled at you, began tapping you on the shoulder, shining his flashlight in your face, you didn't wake up. Shaking you back and forth, yelling at you, you didn't wake up. And you're driving a car in this condition with people, other citizens around. Nothing makes it less serious. As for recidivism factors, in the new case, the court finds the defendant was on community control sanctions to this court at the time that he committed this offense. He has failed to comply with previously imposed sanctions ordered by the courts, including this court. In fact, he was on probation to this court. He had violated just in July. And despite his history, despite the fact that I gave him a break when I first put him on probation, I continued him again with the first PV. And within, a month after getting out of jail, maybe 2, he did this. He's got a significant criminal history. He's been to prison 4 times before already. He's not responded favorably again to previously imposed sanctions. A drug abuse problem that relates to the offense, and he's adamantly denied he has a problem. Even though he's got a history of drug problems, he tested positive for drugs, has drugs on him. He pointed, you're entitled to minimum sentence and mercy. You've been to prison 4 times. You're on probation when you did this. Why do you deserve mercy? Why do you deserve a minimum sentence? You don't. You're 49 years old, and you've been doing this your whole life. Wherefore, is sentenced to this court in case 24 CR 035. Defendant served a term in prison of 9 months. He's given credit for 181 days he's already served. Case 25 CR 1342 is the sentence of the court. Defendant served a term in prison on count 1 of 15 months. That'll be served consecutive to the prison term imposed in 24 CR 035. Since it's consecutive, there's no credit on that case because he's getting all the credit on the first case. 181 days includes credit for both cases. Count 3 is a sentence of 180 days. It's concurrent to the sentence in count 1. Impose the minimum fine of $565 on count 3 in the new case. Both cases, I'm going to suspend the defendant's driver's license for 3 years. That's a concurrent suspension, though. 3 years in each case, but concurrent. The court's going to order defendant pay all costs incurred in both cases. Need to advise you upon your release from prison. You could be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, this is for both cases, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed by this court. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. The court disapproves the defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. That's for both cases as well. 25 CR 1342, I'll order the forfeiture of the contraband and instrumentalities as part of the specification count 1. I'll dismiss the balance of that indictment as well. Lastly, the court finds that consecutive service is necessary to protect the public from future crime and to punish the offender. This consecutive sentences are not disproportionate to the seriousness of his conduct and to the danger he poses to the public. And the court finds that he committed the offense in the 25 CR 1342 case while he was on community control sanctions to this court in 24 CR 035. I think that covers everything. Ms. Contour, is there anything else for the record that I...
Your Honor, for the license suspension, does that begin on the date of the offense or today?
What has his license been suspended? If there's no ALS, then it starts today. If there's an administrative license suspension, he'll get credit for that, but...
I would have to look, Your Honor.
It would start today, is my understanding.
Okay.
Unless it's been suspended. The fact that he hasn't driven, that doesn't get credit for that.
Okay.
Mr. Watson, anything else?
Nothing further, Your Honor.
Thank you.
All rise.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.